Money Radio, thank you for joining us today. It's always a pleasure to welcome Laura Bramnick from TalkRealEstateAZ.com. That's the website, TalkRealEstateAZ.com. Laura is an attorney. She's also a real estate agent, and she's also a consumer advocate for her clients. Whether it's residential, commercial, real estate transactions, land transactions as well. Laura is licensed with the Arizona State Bar and specializes in real estate. Also Arizona Real Estate License, and also a certified instructor with the Arizona Department of Real Estate. TalkRealEstateAZ.com, or you can call 480-624-2705. 480-624-2705. Laura, nice to see you again.
Nice to be here, Sinclair.
Let's talk about due on sale clause.
I think that's an important topic. First of all, what is a due on sale clause?
Yeah, what is it?
In mortgages and deeds of trust, when when you borrow money to buy property or refinance, there's a clause as a general rule. There's a clause in mortgages and deeds of trust that state that the lender, at its option, may call your loan due if you transfer title.
Makes perfect sense. You transfer title to another person.
Right.
They get to call their loan.
But a transfer of title also involves if you transfer your property into an LLC or to a corporation. Let's say that you buy the property in your own name and then you decide to transfer it to a limited liability company. Very common nowadays, especially with rental and investment property.
Sure.
Now, this doesn't apply to commercial property, meaning anything greater than 1 to 4 units. But
a lot of people have
a condo that they rent out or a
Right.
single family home, and that comes under this clause in your mortgage.
Now, as a landlord, you would probably like that extra safety or protection that an LLC might afford you.
It's very common, and I have a lot of clients that do transfer their property into an LLC, because if somebody were to sue you, let's say they get injured on your property,
Right.
then they can only get the assets in the LLC. They cannot go after your personal assets.
Right. That's the liability that you
Right.
get from an LLC.
That's why it's called limited liability company.
Right.
But this technically violates the due on sale clause in
And-
almost all mortgages.
And so then they could demand payment in full.
They could demand payment in full, yes. Now, as a practical matter, if you have one of the major lenders, the Bank of America's, the Wells Fargo, Chase,
Right.
they normally, as long as you make your payments, they don't normally look to see if your title's been transferred. If they see it in an LLC, they normally don't do anything unless and until you go to refinance. And anytime you do something like that, they want your property back in your own name to match the mortgage documents.
So should you just purchase the property in the name of the LLC to begin with?
That's easier said than done. The answer is yes, if you can, you should. However, the lenders are not doing that anymore. Several years ago, before the market crashed, there was a handful of lenders that would allow you to buy your property in an LLC. But even those few lenders have gone away. And it's because mortgages have become tighter, and mortgage companies want to make sure that they can go after the borrower with the deepest pocket.
Yeah, sure.
And so they don't want to limit who they can go after. So unless you have a private lender or a commercial lender, which obviously will charge you a higher rate, or hard money, usually you cannot get a mortgage in an LLC.
So let's say that you do transfer into an LLC. The lender then notices it and says not allowed. You're in default.
Right.
due on sale, pay up. Well, that's not what you want to do. Is there some sort of remedy?
It's very hard to do that, you know, you don't, because if they foreclose, you know, you wanna try to then quickly sell it, because most people don't have the cash to pay off the mortgage.
Right?
So.
Can you just transfer it back?
In most cases, yes. In most cases, yes. You have to look at your documents. With a commercial type bank, usually they'll just send you a notice and you transfer it back and you show them that you've transferred it back and you're good to go.
Okay.
Because they'll send you a notice of default and they'll say you have to correct the default within so many days.
Okay.
Usually they give you plenty of time to do that. The problem becomes if you have a small lender, a private lender, a hard money lender. Many times, once you're in default, they don't even have to give you notice. They can just go ahead and foreclose.
Now, another thing, I'm thinking, a lot of folks transfer property into a trust, a living trust. That's a very
Right.
common thing.
And that is permitted. That is because even though you have a due on sale clause and you technically are transferring title because you're transferring it from you to your trust, the federal government, Congress, passed a law in 1982 called the Garn-St. Germain Act. And that act gave specific exceptions where lenders couldn't call the due on sale clause. And so if you fall under one of the exceptions, then you're fine. And having a revocable living trust, as long as you're the beneficiary,
Right.
is one of the exceptions.
What other exceptions are there?
The other exceptions are if you die and you leave your property to a relative.
Okay.
Usually that's a spouse or a child.
Right.
And the relative has to occupy the property. They can't like use it as an investment property.
Okay.
So if they occupy the property and continue to pay the mortgage, the lender cannot call the due on sale clause.
Okay.
Okay. So, there's a lot of issues. I have issues where a lot of times an adult child has moved into care for an ailing parent, and the
Yeah.
parent dies and they want to stay in the house.
Sure.
But their name's not on the mortgage.
But this would be an exclusion.
This would be an exclusion. Now, many lenders will try to bully them and say you have to get out.
And this is where you come in. You can be
Right.
the attorney representing them and setting everybody straight.
Correct. They really need to make sure that they understand their rights.
You need to make sure they understand their rights, and they need to make sure they contact Laura Bramnick at 480-624-2705. Laura answers her own phone, 480-624-2705, or remember the website, talkrealestateaz.com. talkrealestateaz.com. Good information. Thank you, Laura.
Thanks, Sinclair.